The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns.
Raise your right hand.
Do you swear and affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, Jason. You have the choice today of whether to testify or not testify. Is after talking with your attorney and going through your own thoughts, what is your decision of whether or not you want to testify?
Not to testify.
You choose not to testify.
Yes, sir.
Mr. White, you want to talk a little about how you talked about it with him and gone over with him?
Yes, so Jason, we've met a number of times. We've talked about what your testimony would be, and you understand that even though you might have an opportunity to say your piece, that you would be subject to cross-examination. And I've explained to you that the cross-examination would probably be very intense and relentless. And by subjecting yourself to that, you can change the status of your case. You can make it worse. You can make it better. That's the thing about testifying. You don't know how it's going to go. But it's important that you understand that you have an absolute right under the Fifth Amendment to testify. In your case, no one can prevent you. The judge, the court, no one, is certainly not me, is stopping you from testifying. This has to be a personal choice. On the other hand, if you want to testify, there's nothing this court would stop you from doing that. So whatever it is that your decision is, it is a personal decision that only you can make. Have you had enough time to consult with me, talk about whether or not, go over the benefits and detriments of testifying?
Yes.
Are you deciding not to testify on your own volition?
Yes.
And that's what your personal decision is?
Yes.
Jason, also, Tennessee law requires that the jury fix any fine greater than $50. You have the ability to waive that right and allow this court, Judge Patterson, to decide the amount of any fine, if any. We've gone over the benefits of allowing the court to decide versus the jury to decide. We've given you these recommendations. Do you want to waive your right to have the jury assess fines in this case?
Yes.
Mr. Chen, Mr. Weiss is a thorough attorney. I know he's gone over this with you before. He's obviously went over with you just then at the podium. I just need to make sure that I understand everything that you have obviously consulted with Mr. Weiss, Ms. Morrison, that it is your constitutional right to testify or not testify. If you were to testify, you would be cross-examined by the state. However, while your attorneys can give you advice about their opinion of whether it's a good thing to testify or not testify, ultimately that is your decision. So your attorney asked you this, but now I'm asking. With all that being said, it being your call and your constitutional right to testify or not testify, what is your decision?
not to testify.
So you executed this waiver affirming that.
Yes, sir.
And as Mr. Weiss indicated that the jury does get to set fines over $50. Most people waive that. And I see you signed a waiver here for having the jury testify, and you're allowing the court to set that fine, if any, correct?
Yes, sir.
Thank you, ma'am. County Counsel.
Wait this way.
All right, so procedure, what we'll do is we'll bring the jury in. I'll ask the defense if there's any more proof. From the defense, I'll ask the state if there's any rebuttal proof. And if the answers are what I expect, we'll send the jury out again and have our comments. Okay?
Yes, sir.
All right, bring the jury, please. Please be seated. Good morning, jurors. Hope you had an enjoyable day of R&R yesterday as much as you can enjoy it. Was it relaxing for you? I hope. Didn't have too much fun Saturday night, I hope? No? Okay. All right. We'll start as always, just asking to make sure that you make sure everyone was able to abide by the court's admonition not to be exposed to media, not to talk about the case among yourselves, along with the other things the court admonished. Is that correct? If so, just nod your head. Okay, the record reflects everyone is nodding their head. Okay. All right, Mr. Weiss, any more witnesses for the defense?
The defense rests.
State calling you rebuttal witnesses.
No, Your Honor.
Ladies and gentlemen, you've heard all the proof you're going to hear in this case. What that means is that there are some matters we do need to take up outside of your presence. It may take a little bit of time. I'm not sure how long this will go. However, once that is settled, you'll be brought back in. The court will read to you jury instructions, the thick packet. You don't have to write down what I say. Just pay attention because you'll have a copy to refer to later. There'll be points that both sides want to point out. Once I read the majority of the jury instructions, both sides will have a chance to do their closing statements. The state will close first. The defense will do a closing argument, and if the state wishes, they have a chance to do a rebuttal argument. At that point, we'll finish the jury instructions. We'll pick the alternates, and there's a little special way we'll do that. And the 12 of you who are selected to be the actual jury in this case will go back to jury and deliberate. So that's what's ahead of you. Again, I'm not sure how long it'll be for we bring you back out. Maybe a short amount of time, may not be. Be patient with us, and we'll get you back out as soon as we can. With that, next step is the jury. Otherwise, I think you have the want to make a renewed motion for judgment acquittal. You can at the close of your proof as well. If you wish to. If there's anything.
Yes, Your Honor. Pursuant to Rule 29.
Please be seated.
Pursuant to Rule 29 of Tennessee Rules of Criminal Procedure, the defendant moves for judgment of acquittal renewed
the witnesses called by the defense tipped the balance to the degree where, looking at the evidence in the light most favorable to the state, that any rational finder of fact could not find the element of the offense. Again, this isn't a finding of guilt beyond a reasonable doubt. It's simply a finding that allows the case to be sent to the jury. So, Mr. Weiss, your motion is respectfully denied. Okay, I see a motion to exclude voluntary manslaughter.
Yes, Your Honor. Would you like the state to argue it at this time?
Is it not a lesser?
It is a lesser if the court finds that evidence exists which could cause a reasonable juror, based on the proof presented. We would start, Judge, with Tennessee Code annotated 40-18-110, which specifically reads that the trial judge shall not instruct the jury as to any lesser included offense unless the judge determines that the record contains any evidence which reasonable minds could accept as the lesser included offense. Further, the state has included many cases of first-degree premeditated murder in which the trial courts excluded as a lesser included offense voluntary manslaughter. The case law is very, very clear on this, Judge. A murder will only be reduced to voluntary manslaughter when the provocation was caused by the victim. Adequate provocation is an element of voluntary manslaughter, as is state of passion. The defense has put on zero proof of state of passion, or more importantly, adequate provocation by the victim. Pieces of glass of the nature that the jury saw underneath the futon are not any type of proof of adequate provocation. A witness who heard a female scream in, quote, distress 7 minutes before the location was sent to Katrina Bean is not evidence of adequate provocation. The jury instruction simply, according to the law, should not be given to this jury. They have no evidence, no proof whatsoever of adequate provocation. The cases are interesting. The cases are similar. The courts in each case, when there was some type of argument, in fact, Judge, the cases, in all cases, there is proof of arguments. There is proof of passion, even in some of our cases. But the courts found that adequate provocation by the victim is required and was not found in cases with actual arguments. There has been no proof in this case of an argument. There has been zero proof of even an argument in this case. A much lower threshold than what courts have found in the cases that the state cites. And the reason this was not proper, Judge, is because the state had to be brought before today, is because the state had to wait for the defense to rest. The state didn't.
I hope you know I was just trying to be lighthearted.
Sure. Well, yeah, but procedurally, I hope that all parties understand why this couldn't be raised. But it's the law. And so it can be a lesser included, as the court asked, but it is not a right of the defendant to have this instruction given by the court. We would ask that it be excluded based on the law, Judge.
Just while you're here, I'll tell my here for you, Mr. Weiss, but I can tell you that the threshold to charge an offense, the jury instruction, is less than a preponderance. It's not much at all. And like the motion earlier about the judgment acquittal, this one is taken in favor, light most favorable to the defendant. What I recall, and I'll let Mr. Weiss, fill in the gaps if I miss anything. Clearly, they were in a relationship, which doesn't by itself, mean adequate provocation. But the fact that there was some type of fight, whether the fight was, as the state's theory is, Mr. Chen starting it, and where the victim was basically not contributing to it at all, there was some type of fight between two people who were in a domestic relationship of some kind. And if I recall Dr. Cogswell's testimony, when Mr. Weiss was cross-examining him, the testimony about the knife being held in the same position, I think Dr. Cogswell indicated that it would have come very fast, without much movement, on the part of the defendant. And I believe the language that Mr. Weiss got out of them was either heat of passion or heat of excitement. So that's what I would recall. But if you want to respond to that, you can now. If you want to wait till Mr. Weiss fleshes out, you certainly can.
Well, heat of passion is not mutually exclusive with premeditation. Most first-degree murders involve passion to some extent, right? And so, in our cases cite this. I don't believe that even if you give Mr. Weiss the benefit of the doubt and say, there was proof of an argument, according to Tennessee case law, that's not enough for adequate provocation. There was also proof introduced that there was chasing from the bedroom of the apartment to the front door. I think that could negate any type of argument that it was a heat of passion where there was an argument going on. I think that could indicate to a reasonable juror that she was trying to run away, right? And so I don't believe the proof on the record supports any type of adequate provocation, Judge. Even Dr. Cogswell's testimony. Often in first-degree cases, gunshots are fired back to back to back to back. I don't think it matters that the stabs happen. If the stabs happen 1 second after 1 second, you still have 60 seconds of stab wounds. So respectfully, the state will always trust the sound instruction of the court, but respectfully, I believe that the law supports no instruction on voluntary manslaughter.
Thank you. Mr. Weiss?
Firstly, Your Honor, this looks like a well-written motion, and it's been written for some time. If the court knows my modus operandi, I would love to be able to go through this with a fine-tooth comb and shepherdize each case and look at any subsequent case law on it, and also search for case law that would provide perhaps the opposite conclusion if it existed. I doubt I have time.
Well, so this, of course, I can make a ruling on this after you argue. You don't have to sit down and after looking at this and trusting that the whole case, the essence of the case is in the state's motion. I'd love to hear your argument, but we'll take a break and give you some time to look at it if you wish.
Even if I can't do an adequate job in 5 or 10 minutes.
I'm saying if you want to take, again, this is important enough where if we're closing today, I want to give you not as much time as possible. I want to give you as much time as possible under the circumstances. So we could break till about 10:30, give you a chance to look at some of these cases. If you get into it and decide you need some more time, we certainly will.
Yes, Your Honor. Would the state be courteous enough to send me a digital copy of this?
Of course. Sure.
Yeah, I appreciate that.
We'll
Thank
send
you.
it to you and Ms. Morrison.
Thank you.
Okay, so the court will be in recess till 10:30. And Mr. Weiss, if you get your answers sooner or later, please let me know.
The other motion for jury instructions from the defendants later or at this time as well?
We'll do it that time. We'll take it one step at a time. Consider additional instructions the state wishes.
Oh, no, Your Honor, the defense filed a motion for additional instructions.
Okay, I'll look at that.
Okay, thank you, Judge.
So I can copy it. Chen is in the courtroom. I'm pretty just after looking at your respective motions, let both sides kind of know where I'm at the moment, and feel free to argue accordingly. As far as voluntary manslaughter in general, again, the threshold is not even a preponderance. I'm not saying this is even not even an arrestable thing. However, it seems like the evidence shows that the defendant and Ms. Pace were in a relationship, that at the time this happened, there was some type of argument, there was a heat of passion, some type of heat of passion of some type, where, in a negative way, where there was an argument, a fight, based on what the neighbor downstairs reported, to the degree that there were footsteps. And so, again, while this would not be chargeable at all, the standard is taking the light most favorable to the defense. It seems that for voluntary manslaughter, that it should be at least be charged. You can certainly argue that the elements do not satisfy that. At this point, that's where I am. Feel free to argue differently if you want to add to that. Mr. Weiss, I don't see any evidence of intoxication, other than the victim buying him. And the medical examiner's testimony was a little equivocal on that, but there was no, I don't recall any type of toxicology indicating any level of impairment on the victim. That's not even talking about the defendant, but that even substances were consumed that night. There might have been the wine bottle, but there's no evidence they were consumed that night. As far as self-defense as well, I don't think that's been fairly raised to this point either, simply because, the deadly force that was used, the victim, the defendant would have to be shown to be in reasonable fear of his life to use deadly force. I don't think that's been raised at all. That's where I am, so feel free to, either side wants to start, you certainly can.
Your Honor, surprisingly, I concur with this court's thoughts regarding the voluntary manslaughter. I think the case law is pretty clear of when a lesser included should be included in jury instructions. And I think it is fairly obvious here that there has been certain proof introduced. It will come up. There it is. You heard the testimony from Courtney Brewer, Paglino, establishing a testimony argument took place shortly before the incident. She had recalled hearing yelling and the sound of people running. She heard a woman, specifically a woman, arguing emotionally, so we heard that.
We're talking voluntary manslaughter at this point?
Yes, it is voluntary. And as far as Dr. Cogswell is concerned, as the court hit upon, the injuries sustained by Ms. Pace were frenzied and erratic, committed in a way that's consistent with the heat of passion and excitement. That corroborates the defense's argument that he acted emotionally and overwhelmed and overreacted. There was proof of adequate provocation. It doesn't necessarily have to be a physical provocation. It can be an emotional or psychological. It can be just words. I think that Ms. Brewer also established that. Then there's the Tennessee courts have repeatedly held that voluntary manslaughter instructions are appropriate when there's evidence of adequate provocation and heat of passion. Cases of State v. Williams, State v. Eli. It's not the court's role to assess whether the defendant's serious case is credible, whether it is supported by any evidence in the record. Here, the combination of the eyewitness accounts, forensic testimony, the contextual evidence supports the inclusion of voluntary manslaughter.
Does the state want to argue anything beyond what's already argued?
Your Honor, again, the state understands the court's position. We disagree with it, and there's been holdings that by the Tennessee Supreme Court and Court of Appeals that, quote, it is true as a general rule that no provocation by words alone will reduce the crime of murder to that of manslaughter. So even if an argument is established, the state still doesn't believe that's enough for the record, but the state accepts and understands the court's analysis on voluntary manslaughter.
Okay. But based on what was presenting in court, again, for the record, the court is not finding heat of passion to the degree that the jury needs to find it, but to the degree that it gets charged where it's less than a preponderance, taking the light most favorable to the defense. I do think that the fact that the victim and the defendant were in a relationship, that they had an argument to the degree that it woke up a neighbor downstairs. There's an argument that got physical, or I should take, there was definitely some footsteps involved during this particular passionate argument. So taking the light most favorable to the defense, I think we will charge voluntary manslaughter.
Your Honor, in regards to voluntary intoxication, the court will remember that when everyone entered into Jason's Chen apartment, we pointed out the ball on the desk. And so that was present throughout this entire case. That was well known. So we know that there were drugs in the apartment likely being used, or at least you can take that inference. In addition to that, there was a receipt by Ms. Pace that she had bought hemp that day. So there could also be an inference that she, I mean, when you buy hemp products, I would assume that you would buy them to use them. So it is a low threshold. There is no proof that Ms. Pace or the defendant was intoxicated at the time, but that will, for the defendant, obviously there was no toxicology at the time, but for Ms. Pace, they did do toxicology, but because of an interfering substance, we don't know the THC content, if any, in this case. So that would give an inference that there was marijuana use. As far as wine, there is talk about excessively open wine bottles that weren't finished, closed wine bottles. The court here heard about the glass. There was evidence that was introduced at the trial about the glass. I think that there is enough that raises enough about voluntary intoxication to include that as a jury instruction.
You want me to?
Yeah, well, briefly, Judge, absolutely not. Because I have 40 bottles of wine and alcohol at my house right now does not mean that last night I was intoxicated. That's a silly argument, and there was no evidence of actual drugs in Mr. Chen's apartment. There was evidence of a bong. There was also evidence presented by multiple witnesses that the apartment had no smell of marijuana. The standard is not that you show that there was alcohol and a bong in a house. The standard would be that you show with sufficient proof that either party, but this would be arguing that Mr. Chen was intoxicated at the time of the offense. There has been zero, absolutely zero proof of that. There was proof that the victim had no wine in her system at the time of the offense. Dr. Causation testified that it should have still been in her system by the time the medical examiner's office took her blood, and cannabinoids actually had been tested and came back with a negative result according to Dr. Cogswell. This does not meet the standard in any way, shape, or form of voluntary intoxication. In fact, under this argument, in every single case of murder where there was alcohol or bong in a house, then we've got a good argument for voluntary intoxication. That's not the standard, though.
All right, on this one, the court doesn't find that there was evidence of any intoxication, by either party, much less by the defendant. So I think that as low as the standard is to charge voluntary intoxication, there's such a paucity of evidence in this particular situation, the court's not going to charge voluntary intoxication.
In regards to self-defense, so first I'm sorry, with the opening, there was an argument that could have been made that the defendant acted in self-defense. The defense's theory, however, is that the defendant overreacted and reacted excessively. And so self-defense isn't proper in this case. However, it is the province of the jury to decide whether or not that was self-defense. The jury could think that the defense is wrong and that he didn't have a duty to retreat, he didn't have, and he didn't overreact. They could, however unlikely, could think that. They could think the defense's theory is wrong. As far as the proof at trial, Dr. Cogswell talked about the contusion on the side of Ms. Pace, which is corroborative of the defense's opening, that he kicked her and she fell back. It is indicative that the broken glass is also probative of that same incident where falling back. We can see that something happens in the kitchen, living room area, but it ends up in the bedroom. How they get back there and all those different things, if the proof that came into the trial could show, or I'm sorry, the proof that did come to the trial could lead a reasonable juror to believe that Mr. Chen was acting in self-defense at first, and then overreacted as well.
State you want to hear on that?
Your Honor, the defense just said, quote, self-defense isn't proper in this case, pointing to opening statement. Mr. White is really ignorant of the law in the state of Tennessee, and further, the idea that there's evidence that Mr. Chen kicked Ms. Pace is only evidence of further abuse. It is not evidence of any type of self-defense. And so the state, again, would ask that self-defense is a higher standard than voluntary manslaughter when it comes to adequate provocation. There has been no proof presented by the state or the defense that Mr. Chen could have or did act in self-defense. It is not deserving of an instruction.
All right, on this particular issue, what we do have is that the defendant, I believe, is 6'1", and, you know, large individual. The victim's size is barely 5 feet, around 100 pounds. The only evidence of anyone having a deadly weapon is the defendant. There's no evidence that the defendant was put in a reasonable state of fear where he could have believed that self-defense would have been justified. So I don't think that self-defense has been fairly raised by the proof the court has heard, so that the request for self-defense instruction be denied.
Sure.
Okay. It is 15 to 11. A couple ways we can do this. I'd like to go ahead and need to prepare these charges. I did, as the parties know, I did have self-defense, voluntary intoxication in there for what your day would bring. I need to tweak the jury instructions. I'd like to go ahead and charge them. It'll probably take us to 11:40-ish, 11:50-ish, I would think. We can take a lunch break, come back and close at that point, or just go straight to closing after that.
Your Honor, the state would prefer that the court instruct the jury and then closing arguments be after lunch back to back. I would prefer that closing arguments not be split up. I don't think that's the best way to do it. And also in terms of jury instructions, there's a blank when it's the abuse of corpse instruction. There's a blank for that second prong that includes disposing of a body in a way that's in violation of Tennessee Code annotated, and then it's blank. We would argue that that would be under TCA 39-14-505, which is aggravated criminal littering. It makes it aggravated if the littering, the matter of littering is over 10 pounds.
First time I had one of these, so does that require a jury instruction on aggravated littering so they can find out if there's a violation of it?
I think your parent jury instructions do contemplate the elements of the predicate offense to be instructed.
All right, let me tweak these instructions. We'll be in recess until that's done. I'm not sure when that'll be, hopefully next 15 or 20 minutes. I'll give the parties a copy before we bring up the jury. Okay?
Thank you, Judge.
Thank you.
Thank you.
references to the defendant testifying, taken out, references to the aspect we already talked about.
Your Honor, do you want to bring the defendant up?
Yes, absolutely. Thank you. Bring up Chen. I'll ask if there's any tweaks about either side.
Your Honor, I didn't realize, this makes sense, but I didn't realize that, I guess reckless homicide comes after ag assault just because it's lesser. I didn't realize that.
Then the E felony of criminally negligent homicide is down there too.
Yeah, that's interesting. I've never noticed that.
Both sides, if you want to go straight to the abuse of court, you certainly can. Again, I think the references to, again, the defendant testifying was the last thing I wasn't sure about. That's been modified to show that he hasn't testified, and the jury can't hold anything against him for that. But once the parties finish reviewing it, run through a proceeding for injury.
Your Honor, with the impeachment of a witness, I think there might be the beginning of a sentence that might have been deleted that's not all there.
What page are you looking at?
There's no page number, just impeachment of the witness. There's 3 paragraphs. The last paragraph, it starts off with impeach.
Thank you. When the testimony of a witness is impeached, the jury has the right to disregard.
Yes, sir. also an instruction for a prior statement of defendant?
I kept that because wasn't there testimony about when Ms. Pace, Katrina Pace, was talking to the police officers, they said that he gave statements that were...
There was also the written statements that were collected and no one's really gone.
Okay.
That's a good one.
Okay. Good to go? Both sides ready to proceed?
Yes, sir.
Bring the jury in when they're ready, please. Please be seated. Ladies and gentlemen, I'm about to read final jury instructions. Please pay attention. You don't have to write them down. You will all have a copy. There will be at least one, probably several copies back to the jury and make you deliberate. But pay attention because the issues that are in these instructions do pertain to the issues that came out during trial. And so there may be one or two things that you see that you want to follow up with. Of course, the parties will follow up with them as well when they do their regular closings. Members of the jury, the evidence in this case has been completed. You will now be instructed as to the law applicable in the case. This covers your duties and the general rules that apply in every case. It also covers the offenses that are charged and included in the presentment and lists their elements. It includes some rules that you must use in evaluating particular testimony and evidence. Finally, it also includes the rules that you must follow during your deliberations in the jury room and the possible verdicts that you may return.
Your Honor, I'm sorry. Are you intending for this to be scrolled?
Actually,
Didn't know. I apologize.
no. Thank you, gentlemen.
Uh-huh.
It is your duty to carefully consider all these instructions. The order in which these instructions are given is no indication of their relative importance. Moreover, do not assume that because a particular instruction is given, it suggests anything about the facts of this case. You should not single out one or more instructions to the exclusion of one or more others, but you should consider each instruction in light of and in harmony with the others. Count 1 of presentment 315-228 charges the defendant, Jason Chen, with the offense of first-degree premeditated murder on or about November 23rd, 2022, Hamilton County, Tennessee. This charge includes the following offenses: first-degree premeditated murder, second-degree murder, voluntary manslaughter, aggravated assault, reckless homicide, reckless aggravated assault, criminally negligent homicide, assault, and reckless endangerment. Count 2, the presentment 315-228, charges the defendant, Jason Chen, with the offense of abuse of a corpse on or about November 23rd, 2022, in Hamilton County, Tennessee. This charge includes the following offense: abuse of a corpse. The presentment in this case is the formal written accusation charging the defendant with one or more crimes. It is not evidence and does not create any inference of guilt. To presentment 315-228, the defendant, Jason Chen, pleads not guilty. The plea operates in law as a denial of every allegation of guilt contained in the presentment and every element of fact in the offenses charged in the presentment. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all the evidence in the case you determine beyond a reasonable doubt that the defendant is guilty of an offense charged or included in the presentment. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. This burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state has the burden of proving beyond a reasonable doubt all of the elements of the offense, and that the offense was committed before the presentment was found and returned on March 3rd, 2023. The state has the burden of proving by a preponderance of the evidence that an offense charged or included in the presentment was committed in Hamilton County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. The venue of an offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that an offense charged or included in the presentment was commenced or consummated in Hamilton County, Tennessee, you must return a verdict of not guilty. At times during the trial, the court has ruled upon the admissibility of evidence. Do not concern yourself with these rulings, either by such rulings, these instructions, or any other remarks that I've made. Do I mean to indicate any opinion as to the facts or as to what your verdict should be? Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in the case. You are also the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in the light of your own observations and experience in life. Any person who commits the offense of first-degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the victim, and 2, that the defendant acted intentionally, and 3, killing was premeditated. context of this offense, a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion. The accused commits the act after the passion has subsided. Any person who commits second-degree murder is guilty of a crime. To find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, the defendant acted knowingly. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. In the context of this offense, the person acts knowingly when the person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. In the context of this offense, a person acts intentionally when the person acts with a conscious objective or desire to cause the death of the alleged victim. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. In the context of this offense, a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, a person acts knowingly when a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another, and 2, the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of circumstances surrounding or result of his or her conduct when the person is aware of the nature of the conduct, that the circumstances exist, so that the conduct is reasonably certain to cause the result. Any person who commits the offense of reckless homicide is guilty of a crime. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. In the context of this offense, a person acts recklessly when the person is aware of, but consciously disregards, a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, a person acts knowingly when the person is aware that his or her conduct is reasonably certain to cause the death of the alleged victim. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another, and 2, that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, disfigurement, and physical pain or temporary illness, or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or the result of his or her conduct the person is aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, that the conduct is reasonably certain to cause the result. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. The person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the victim. In the context of this offense, the person acts knowingly when the person is aware that his or her conduct is reasonably certain to cause the death of the alleged victim. In the context of this offense, the person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find beyond a reasonable doubt that the defendant was criminally negligent You must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. Defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim or third party, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim or third party causing the death is a natural and probable result of the defendant's criminal negligence. Any person who commits the offense of assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally, knowingly, or recklessly caused bodily injury to another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness, or the impairment of a function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, or that the conduct is reasonably certain to cause the result. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or the result of his or her conduct, and the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Any person who commits the offense of reckless endangerment is guilty of a crime. When you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury. And two, that the defendant acted recklessly. The threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, physical pain or temporary illness, or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or result of his or her conduct, and the person is aware of, but consciously disregards, a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, or that the conduct is reasonably certain to cause the result. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1A, that the defendant physically mistreated a corpse in a manner offensive to the sensibilities of an ordinary person, or B, that the defendant disposed of a corpse in a manner known to be in violation of Tennessee Code Annotated 39-14-505, which defines the offense of aggravated criminal littering as littering in amount exceeding 10 pounds in weight or 15 cubic feet in volume, and that the defendant acted without legal privilege, and that the defendant acted knowingly. In deciding whether the act was offensive to the sensibilities of an ordinary person, the jury must avoid subjective, personal, and private views and evaluate the sensibilities of a hypothetical average adult person, applying the collective view of the adult community as a whole. Ordinary person means a person of ordinary care and diligence in relation to a particular thing. Littering means knowing, placing, dropping, or throwing litter on any public or private property without permission and not immediately removing it. Litter includes garbage, refuse, rubbish, and all other waste material. Garbage includes putrescible, animal, and vegetable waste resulting from the handling, preparation, cooking, and consumption of food. Refuse includes all putrescible and non-putrescible solid waste. Legal privilege means a particular or peculiar benefit or advantage created by law. A person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, the circumstances exist, that the conduct is reasonably certain to cause the result. The requirement of knowledge is also established if it is shown that the defendant acted intentionally. A person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Before the defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was approximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such a case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may also have been a proximate cause of the death. However, it is a defense to homicide if the proof shows that the death was caused by an independent intervening act or omission of the deceased, or another which the defendant, in the exercise of ordinary care, could not reasonably have anticipated is likely to happen. However, if, in the exercise of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of the death. It is not necessary that the sequence of events or the particular injury be foreseeable. It's only necessary that the death followed in the general field of danger, which the defendant should have reasonably anticipated. If some other circumstance caused the victim's death, unrelated to the defendant's actions, that would be a defense to homicide, unless the circumstance was the natural result of the defendant's act. If you find that the defendant's acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, you must find him not guilty. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, The burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the charge or an included offense. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charges you that if, from the whole proof in the case, you are satisfied beyond a reasonable doubt that the defendant committed the charge or an included offense, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the charge or included offense, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or if you have a reasonable doubt as to whether he has been identified in the whole body of proof in the case, you should return a verdict of not guilty. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact of issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact of issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules for judging whether you believe a witness. It may help you to think about these questions. 1. Was the witness able to see or hear clearly? How long was the witness watching and listening? Was anything else going on that might have distracted the witness? 2. Did the witness seem to have a good memory? 3. How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Did the witness seem to evade the questions? 4. Has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? 5. Does the witness have any bias, prejudice, or personal interest in how the case is decided? 6. Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? 7. In general, does the witness have any special reason to tell the truth or any special reason to lie? 8. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. You may conclude, however, that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. The testimony of a witness may be discredited or impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, Immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. The testimony of a witness may also be impeached by proving that he or she has made a prior inconsistent statement. That is, a material statement that he or she made out of court that is at variance with his or her testimony on the witness stand. However, the earlier statement is brought to your attention for the sole purpose of discrediting or casting doubt on the accuracy of the witness's present testimony here at the trial. You may not use the witness's earlier statement as proof that something said in it is true. When the testimony of a witness is impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony and by the facts and circumstances proved on the trial. During the trial, you heard expert testimony. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact of issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it's up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. The court instructs you that while there is evidence of an oral or written statement given by the defendant in this case, you may take it into consideration with all the other facts and circumstances proven in the case. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe the statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given to such statement. If you decide the statement was made, you should consider with all the other evidence in the case in determining the defendant's guilt or innocence. If from the proof you find that the defendant has committed acts other than those for which he is on trial, you may not consider such evidence to prove his disposition to commit crimes such as those for which he is on trial. This evidence may only be considered by you for the limited purpose of determining whether it provides 1. The complete story of the crime. That is, such evidence may be considered by you where the prior acts and the present alleged crime are logically related or connected or are part of the same transaction, so that proof of the other tends or is necessary to prove the one charged or is necessary for a complete account thereof. 2. A scheme or plan. That is, such evidence may be considered by you if it tends to establish that the defendant engaged in a common scheme or plan for the commission of 2 or more crimes so related to each other that proof of one tends to establish the other. 3. The defendant's intent. That is, such evidence may be considered by you if it tends to establish that the defendant actually intended to commit the crime with which he is presently charged. Guilty knowledge. That is, such evidence may be considered by you where guilty knowledge is an essential element of the crime charged, and evidence of the other acts tend to establish that the defendant possessed this knowledge at the time of the commission of the crime presently charged. Such evidence of other acts, if considered by you for any purpose, must not be considered for any purpose other than that specifically stated. The state has a duty to gather, preserve, and produce at trial evidence that may possess exculpatory value. Such evidence must be of such a nature that the defendant would be unable to obtain comparable evidence through reasonably available means. The state has no duty to gather or indefinitely preserve evidence considered by a qualified person to have no exculpatory value, so that as yet unknown defendant may later examine the evidence. If, after considering all the proof, you find that the state failed to gather or preserve evidence, the contents or qualities of which are issued, and the production of which would more probably than not be of benefit to the defendant, you may infer that the absent evidence would be favorable to the defendant. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be a hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving of the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts known to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by the facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the way to be given to it are questions for you to determine. Any attempt by a person to conceal evidence is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Whether the evidence presented proves beyond a reasonable doubt that the defendant concealed evidence is a question for your determination. If this fact is proven, it alone does not allow you to find the defendant is guilty of the crime alleged. A person entirely innocent of a particular crime may attempt to conceal evidence, and the concealment may be explained by proof offered or by the facts and circumstances of the case. However, because an attempt by a defendant to conceal evidence may be caused by a consciousness of guilt, you may consider this fact, if it is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. It is for you to determine whether there was any attempt to conceal evidence by the defendant, the reasons for it, and the weight to be given it. The court has charged the jury concerning an inference the jury may make in regard to certain evidence in this case. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence, or both, whether it exists in the evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanation along with all the evidence to determine not only the correctness of the inference, also to the reasonableness of the defendant's explanation. You are not bound to accept either the inference or the defendant's explanation. The state must prove beyond a reasonable doubt every element of the offense before the defendant can be found guilty. defendant has not taken the stand to testify as a witness, you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take a stand on his own behalf. His election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. During your deliberations, you must not communicate with or provide any information to anyone about this case by any means outside the jury deliberation room. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. During this trial, you have been permitted to take notes for your own use during your deliberations. The notes you may have taken should not be considered to be a transcript of the testimony. As such, once you retire to the jury room, you may refer to your notes, but only to refresh your own memory. You may not read from your notes to your fellow jurors or otherwise inform them of what you have written. The notes may contain errors. They may be understood or taken from context, since they could only pertain to part of the testimony and are not an exact account of what was said by the witness. You are free to discuss the testimony of the witnesses with your fellow jurors, but each juror must rely on his or her own memory as to what a witness did or did not say. Upon conclusion of your deliberations, the court will collect and destroy all of the notes taken by any juror. Count one of the presentment includes, in addition to the charged offense, one or more lesser offenses. The offenses are listed in order from greatest to least. In reaching your verdict on count one of the presentment, you shall first consider the offense charged in the count. If you unanimously find the defendant guilty of the charged offense beyond reasonable doubt, you shall return a verdict of guilty for the charged offense. If you unanimously find the defendant not guilty of the charged offense, or have a reasonable doubt of the defendant's guilt of the charged offense, you shall then proceed to consider whether or not the defendant is guilty of the next listed offense. You shall not proceed to consider any lesser included offense, so you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or if you unanimously have a reasonable doubt the defendant's guilt of the immediately preceding greater offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in count one, you shall return a verdict of not guilty on that count. The crime charged in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty on one or both counts. Your finding as to each count must be stated in your verdict. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so while respecting individual judgment. Each of you must decide the case for yourself. Do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. Do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations and ensure that they're conducted in a business-like way and everyone has a fair chance to be heard. When you have reached a verdict, you will return with it to this courtroom and your foreperson will deliver the verdict form to the court. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. If, however, you find that the state has not proven the defendant's guilty beyond a reasonable doubt, or if you have a reasonable doubt as to the defendant's guilt, then you must find him not guilty. You will be provided with forms of all possible verdicts in this case. The jury will complete the forms, and your foreperson will sign and date them. The verdict forms that you will receive read as follows. With respect to count 1, Resolution 315-228, we, the jury, find the defendant, Jasmine Chen, please mark one of the following verdicts: guilty of first-degree murder, guilty of first-degree premeditated murder, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of aggravated assault, or guilty of reckless homicide, or guilty of reckless aggravated assault, or guilty of criminally negligent homicide, or guilty of assault, or guilty of reckless endangerment, or not guilty. With respect to count 2 of Resolution 315-228, we, the jury, find the defendant, Jasmine Chen, please mark one of the following verdicts: guilty of abuse of a corpse, or not guilty. Members of the jury, you have heard and seen all the evidence in the case. After lunch, parties will have the opportunity to present their closing arguments. Under the rules of criminal procedure, the state will argue first, and the defendant will have an opportunity to present his closing argument. The state may then, if it chooses, argue in response or in rebuttal to the defendant's argument. Closing arguments are designed to present to you the parties' theories about what the evidence has shown and what conclusion may be drawn from the evidence. Remember, what is said in closing arguments is not evidence. You've already heard and seen all the evidence in this case that we may properly consider. During their closing arguments, the parties may mention points of law or refer to these instructions that the court has given you. However, the law that you must follow in reaching your verdict is the law that the court has given to you in these final instructions. If there's any difference between what the parties say about the law, what this court has said in its final instructions, you must follow the court's instructions. Ladies and gentlemen, those are the instructions. It is 12:20. Terry, can you break it along, please? Yes, sir. You're going off campus, so we're going to take an hour-and-a-half lunch. So it'll be time to have lunch. Be prepared. Schooling arguments will probably be lengthy. It's 12:20, so parties and jury be back here at 10 minutes to 2. Voting on. Needs to bring up before we take our lunch recess?
No, you're fine.
After the reading of the jury instructions, it's not so much an objection, it's just a question for the court. Do you perceive there to be an issue with the use of corpus instruction? Because, well, first off, I'm not sure if that's a continuing offense, but if it's not a continuing offense, then a state would be required to make an election of offenses. So, I've never encountered that situation before. I've researched this slightly. I
Please, be seated. Basically, the statement relates to the series of abuse reports, one that was treated in a manner that offended the sensibilities of an ordinary person, and two, that it was in violation of a law.
If he's found guilty of that offense, we won't know of which one.
Generally, got a response to that?
No, Your Honor, I'm actually not sure under this statute whether election is required. If the court wants to play it safe and require that the jury pick one or the other, maybe that's the safest route to go, but I haven't looked up, the jury instruction says or. So we can research it, but I'm also for appellate review purposes fine with requiring the jury to choose which one.
I do know that we've given it to juries, like aggravated burglary cases, for example. Felony theft or assault is the indictment. That's been found to be fine. So I don't think there's no problem so far. To be safe, I may add in that final form under use of a corpse, one or two theories, we'll have to check one or the other.
You could do that. It also makes me think of aggravated assault. We are not required to elect under which category of aggravated assault, so I'm not sure if it's analogous or not, but we're not required to elect. It can either
Fine so far, just whether or not
Sure.
the jury instruction should be tweaked.
Aggravated assault, I think, is a continuing offense. I don't know if an abuse report is, and I guess it could be, but
Based on the littering component of it, of course, I think it probably lends itself to the fact that it might be. Right? The litters.
I have never considered the issue.
Okay, let's do this then. Do one more thing I get to look at over lunch. You guys enjoy lunch. I'll get ready for your closing, I should say, and I'll let you know what I might get.
Thank you, Judge.
Thank you. Recess till 1:50. Bring up Mr. Chen.
Yes, Judge.
For our discussion in chambers, I will reread the use of the corpse, where it's just one theory. Some tweaks to that.
Mr. Honor, will you say, make any statement on the record about that?
So, I mean, well, I can say in chambers, we discussed how to proceed. And I'll say, I'll just go through it, and I'll say, is this correct?
Will you verify that all parties agree
Yes.
to that solution?
No, you can't do it. He's got it. I just got to put there temporarily. I don't know where to put it. Temporarily. No, I'm trying to go.
Please be seated. Sure, I'm sure you gathered that the jury instruction we worked on was a fluid project, kind of tweaked it all the way up, including when I was reading it to you, so I had to change one of those subsections. Since, or I should say over the break, we talked with parties, and there's going to be a modification to the abuse of corpse jury instruction. The littering aspect will not be part of it. It's just one theory that the state is alleging happened, so I'm going to reread that to you just so there's no confusion. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant physically mistreated the corpse in a manner offensive to the sensibilities of an ordinary person. And two, that the defendant acted without legal privilege. And three, that the defendant acted knowingly. And deciding whether the act was offensive to the sensibilities of an ordinary person, the jury must avoid subjective, personal, and private views and evaluate the sensibilities of a hypothetical average adult person, applying the collective view of the adult community as a whole. Ordinary person means a person of ordinary care and diligence in relation to a particular thing. Legal privilege means a particular or peculiar benefit or advantage created by law. A person acts knowingly with respect to the nature of circumstances surrounding the result of his or her conduct when the person is aware of the nature of the conduct, that the circumstances exist, or that the conduct is reasonably certain to cause the result. The requirement of knowledge is also established if it is shown that the defendant acted intentionally. A person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause of the result. Again, for the record, this is something that the state has agreed to. Is that correct?
Yes, Your Honor.
It's something that the defense has agreed to. Is that correct?
Yes, Your Honor.
Remember, what is said in closing arguments is not evidence. You have already heard and seen all the evidence in this case that you may properly consider. During the closing arguments, the parties may mention points of law or refer to these instructions that the court has given. However, the law that you must follow in reaching your verdict is the law that the court has given you in these final instructions. If there is any difference between what the parties say about the law and what the court has said in these final instructions, you must follow the court's instructions. With that, since you've already heard all the evidence in the case, and your notes are to help you in understanding the evidence, at this point, you must all put your notepads under your chair. You're not allowed to take notes during closing argument because it's not evidence. But you may refer to your notes in your stay ready to close.
Yes, Your Honor.
DVD, prosecution not time.
Prosecution might go with it. What's in the bags is a matter of perspective. For one person in the courtroom, was contained in Exhibit 138-6, found on the banks of the Tennessee River in Hamilton County, was an inconvenience. Something that needed to be gotten rid of, discarded like a piece of trash. Something that you don't care about. But to other people in the courtroom whom you've heard from today, it's something, and not today, but over the course of this week, something to be cherished, something precious, something that you'd be willing to go to the ends of the earth to find and bring home safe. What's in the bag? Jasmine Pace. The court has instructed you on the law. And this case really boils down to premeditation. What is premeditation? Well, it's a conscious decision, a choice to engage in murder. The court told you already that it need not exist for any definite period of time. Not an hour, not a day, not a minute, not even a second. And as we talk about premeditation, I'm showing you what's already been admitted into evidence as Exhibit 129. It's a video, you've seen it, and I think it bears seeing again. But not for the reason that you're thinking. It's 5:59 p.m. on the 23rd of November, 2023. You can see on the screen Mr. Jason Chen wheeling this suitcase towards his Toyota Camry in preparation for driving to Suck Creek Road and dumping Jasmine Pace to sit until found by law enforcement on December the 1st. The video stops here. We've all approached a traffic light. The light was turned yellow. You can see it here. As someone approaches this traffic light, they have a choice. You step on the gas, or you step on the brakes. You consider, what time of day is it? Are there pedestrians? What's the traffic look like? Are you running late? Is there a need to get where you're going quickly? All things that your mind processes in an instant. You make the conscious choice to either hit the brake pedal or to go hammer down. And as we'll see, silver car, when faced with that decision, just like Mr. Chen, accelerated, kept going, didn't stop. I want you to keep that in mind as we start going through the proof. What opportunities did Mr. Chen have during this to take the off-ramp away from violence, away from murder, away from 60 stab wounds? And it's important to know the timeline. And how long does it take to choose to kill Miss Jasmine Pace? Mere seconds. Our story starts at 11:27 p.m. when Miss Jasmine Pace leaves her parents' house. You've seen the pictures of it. She drives from her residence to Jason Chen's apartment at 110 Tremont Street. We can see her arriving at 11:42. A minute before, her My Chevy app shows that her ignition turns off in her car. And people asked in the case in chief, who is the person walking towards the door of the apartment? The state's position is that that's Miss Jasmine Pace. The last time she'd ever be seen alive. Then at 2:11 a.m., the defense called a witness whose name is Courtney Paglino Brewer. She was awoken by a scream. Lasted several seconds, she described. She heard footsteps chasing away from the bedroom towards the front door. She heard a female voice that she described as sad but assertive. The tail end of an argument is what was said. And then she hears the front door slam to Mr. Chen's apartment, not the interior door. She told you she knows what the interior door sounds like. She knows what the front doors to the apartment sound like when they slam shut. And it was the front door to the apartment. She hears sounds of walking, but what's very important is she doesn't hear glass breaking, bottles hitting the floor, nothing. 2:15 a.m., Miss Katrina Pace sends a pin of her last location to her mother. Miss Jasmine Pace sends it to Katrina. Now, there's two options, sure. But circumstantially, we know that it's Jasmine that sent that message, because there's only two options. It's either Miss Jasmine Pace in a cry for help, letting her family know where she is, or it's Mr. Jason Chen using the phone, sending a message to Katrina Pace, Jasmine's mom. For what purpose? To get caught? We know he doesn't want that to happen, based on everything else that we see after. So by process of elimination, it's Jasmine Pace. At 2:31 a.m., Mr. Chen's downstairs neighbor, Courtney Paglino Brewer, hears a television turn on in Mr. Chen's bedroom. At no point does she describe sounds of toilets flushing, person retching on the floor. No, she hears what? Garbage disposal? Washing machine. That's at 3 a.m., about 1 hour after the murder. We next move forward to 4:04 a.m., about 1 3/4 hours, or 1 hour and 45 minutes after the murder. And what starts happening? Jasmine Pace is dead, but her phone starts springing to life. Exhibit 126 shows at 4:04 through 4:28 a series of messages. I ask for you to compare Exhibit 126 to 139. So what? We scroll over. Mr. Chen is now attempting to access Jasmine Pace's bank accounts. How does he know that? Because he's got her bank card right there. He has unfettered access to her property that she brought with her. Phones, driver's licenses, credit cards. Moving forward to 9:52 a.m., now 7 3/4 hours, or 7 hours and 45 minutes after Miss Jasmine Pace was murdered, we get to Tinder. We get to the Tinder data on Mr. Chen's cell phone. And what does it show? Oops. What's it show? I guess we're dating now. Ask yourselves, is that the mindset of a person who's stricken with grief? Or is it the mindset of somebody who has zero remorse, who does not care, that would take a body, put it in garbage bags, load it into the suitcase, load it into their car, drive it out to the wilderness, and dump it on the side of the road? Which is consistent? Your common sense tells you that it's the latter. Shortly after, at 10:29, we see Mr. Chen emerge from his apartment for the first time on the 23rd. He's wearing a very distinctive hat. Anything goes. This hat's important. Probably wondering, why would we introduce a hat into evidence? It's because, ladies and gentlemen, this is the one article of clothing that through it all never leaves Mr. Chen's person. We can see here on the Arctic video, starting at 10:29, Mr. Chen come out of his apartment wearing all black. When he steps into the sunlight, you see the red and white of the Anything Goes hat. See it right there. He then gets into his car, and he goes where? To the Walmart. Curious thing, though, as Mr. Chen rounds the corner of Tremont Street onto Fraser Avenue in the North Shore of Chattanooga, he's by himself. There's no one in the front seat. So what? We can see the Anything Goes hat. We can see Mr. Chen. We can see his car. The so what is that at 10:42 a.m., both his phone and Jasmine Pace's phone arrive at the Red Bank Walmart just a mere minutes away. And what does Mr. Chen do? He goes into the Walmart. We can see him wearing all black in Exhibit 18. Wearing, you guessed it, Anything Goes. Mr. Chen then selects various items while he's shopping in the Walmart, but not before he sends this. Good morning. Slept like baby? Made myself a matcha. In an attempt to create an alibi, he's not there. He's somewhere else. you must ask yourselves, is that a sick joke? Slept like baby? Sent to the person that you just stabbed 60 times? Is that the conduct of somebody who doesn't know what they're doing? They're just frantic? Or is it methodical? Does it show a desire in their mind to try to divert attention away from themselves? He uses a photograph to place him at Starbucks rather than Walmart, where he's buying cleaning supplies, towels, Band-Aids. He checks out at 11 o'clock a.m. and then immediately goes to Sup Creek. The location that Miss Jasmine Pace was ultimately found inside this suitcase being indicated by the red pin with body location in the middle. You can see that he's going to the west and to the south of Sup Creek Road, looking for a good spot. And he found that. He returns home at 12:38, carrying his Walmart bag, wearing his anything goes hat, where he stays for several hours and begins the laborious project that is cleaning up the copious amounts of blood that had been spilled in his apartment. Then at 12:43, after he's been home for just a few minutes, some interesting activity starts on Miss Jasmine Pace's phone. At 12:23, on the 23rd of November at 12:43 p.m., he starts trying to get into Jasmine's iCloud. Why? Why? So he can have unfettered access to the digital files, so that he can start creating a further alibi, so that he can begin the process of impersonating his victim to make it appear as though she's still alive, to buy time. That's not the conduct of somebody in a frantic panic, doesn't know what they're doing. That is the conduct of somebody who is cold and calculated. We then see Mr. Chen again later that afternoon at 1:36. This is when he takes the trip from his apartment at 110 Tremont Street and goes to Walgreens the first time. You'll note that his appearance has changed. See how he's wearing a light-colored top and black pants? Different than what he was wearing at Walmart, but again, he's wearing his favorite anything goes hat. One of the jury questions was, what is the significance of item 153? Why was it so important to collect a quarter zip sweatshirt? Most importantly, why was it so important to collect this quarter zip sweatshirt? As you'll see here in a little bit, ladies and gentlemen, it's got a very distinct look. Mr. Chen will wear a black shirt under it. You'll see very clear that he continues to wear this, including when he eventually goes to dump the body. That's the reason. I'm going to set this over here next to the anything goes hat. Make a note of the V produced by the opening of the neck beneath the head. We can then see Mr. Chen drive off, again wearing his red hat and his gray hooded sweatshirt. You've seen the videos. Mr. Chen buys what at Walmart or Walgreens? More cleaning supplies. Isopropyl alcohol. He returns home, but leaves again at 2:56 p.m. The purpose of this trip is it's an extended one. He's going to scout Sup Creek Road the second time that day. He's again wearing the gray hooded sweatshirt and the anything goes shirt or hat. But at 4:03 p.m., while he's still out looking for a place to dump Jasmine Pace's body, he sends this message. Hey, are we still good for dinner tonight? A message which shows is read by Jasmine Pace. I remind you where Mr. Chen is at this moment in time. Where the body is found. Again, slept like Davy. He's still good for tonight. Is that the conduct of somebody who's frantic or someone who's depraved? Then we fast forward to 5:59. You've seen it. Mr. Chen emerges from his apartment with a suitcase. Watch as he tips it over. How heavy it is. Almost pulls him to the ground. Watch as he struggles. Here we go. Tipping it over. See it? Watch as he struggles to go around the corner towards the light post. Right there. Because it's not clothes. He's not going on some trip. It's a person. It's Jasmine Pace. 98 pounds, soaking wet. 5 foot 2 inches tall. In a rolling suitcase. He then drives past. Again, wearing his anything goes hat, his gray shirt. He heads to Sup Creek, disposes of Jasmine Pace, and goes to Walgreens again. But not before he makes a pit stop. He makes a pit stop at Walgreens. Remember Mark Hamilton, the cell phone forensics expert, when he testified? He said that Jason Chen's indicators were red, Jasmine Pace's were green. Miss Pace, despite actually being on Sup Creek Road in this suitcase in the cold November night, her cell phone in Mr. Chen's possession ends up at Walmart. Why? It reconnects to the network. Why would Mr. Chen do that? Remember that read receipt? He's now turning on strategically his phone and her phone to create instances where it appears as though she's online, but he's nowhere around. His phone goes dark, her phone turns on. Her phone goes dark, his phone turns on. It's manipulation of digital evidence to try to distance himself from the fact that he's disposing of the body. And we know this because at 6:49 p.m., Miss Jasmine Pace's cell phone with the IMEI number disappears. It's off the network. The SIM card is out of the phone. The SIM card that's in evidence in 167-2. SIM card which was extracted and shown to belong to Miss Jasmine Pace. The defendant enters the Walgreens, again wearing this gray hoodie, completely zipped down, large V on the neck, with a black shirt under it, white shoes, and his ever-present anything goes hat. He heads home. But he's got a problem. He got rid of the body, but there's another big piece of evidence sitting in the parking lot of his apartment. It's Jasmine Pace's car. So, at 8:26 p.m., he dons a disguise. Think about it. You've now seen his goings and comings at Walgreens, Walmart, the Arctic videos. Does he ever wear a face mask? No. He wears the face mask because he knows where Jasmine's car is located. It's right next to this room. But he knows that that room has a ring camera. You've got all the ring videos and evidence, which predate November the 23rd. See him looking at it. He knows it's there. So he's got to hide his appearance. Again, to try to cover up his misdeeds. Ms. Pace's car then at 8:27, 1 minute after the ring video, car starts up and we have hard acceleration twice during a trip from 110 Tremont Street to 900 Mountain Creek Road. Why? The state would tender that it's because he's not familiar with this vehicle. He doesn't know how it drives. He doesn't know how the accelerator works. And we can see him in his disguise, hood up, blue surgical mask, driving Jasmine Pace's car. He does drop it off at 900 Mountain Creek Road. You've seen that happen. You've then also seen the ride share come and pick him up 9 minutes, 8 minutes after 8:41 p.m. And then you've also seen this. Oops. Jason Chen getting out of the car, wearing his plaid shirt over his white hoodie. The white hoodie in Exhibit 152. Exhibit 143, this plaid shirt. And he goes into his apartment. Now, how might somebody who's upset about what they have done react? How? I can tell you what Mr. Chen did. Less than 1 day after stabbing a girl 60 times in his apartment, 6 hours after taking a body and throwing it on the side of the road, Mr. Chen says to his buddies, "I'm getting on in like 5 minutes." The entire conversation is there. They're talking about playing video games. Says COD, Call of Duty. After engaging in actual physical violence, he goes online to get some more. Then we fast forward a couple of days, and Mr. Chen does something somewhat unexplainable. He takes Jasmine Pace's cell phone, takes his cell phone, removes the SIM card from his phone, and puts it into Jasmine's. And he begins his cell phone data from T-Mobile, Exhibit 136, shows that where he had been using an iPhone XR, he now starts using Jasmine Pace's phone. Again, why? Because he now will have unfettered access to all of her social medias. He can start posing as her more effectively, communicating with the family. giving the impression that she's not dead so that they don't come looking for her to buy more time to clean up his apartment. So let's talk about the crimes themselves now that we have the timeline down. Abuse of a corpse, as the court has instructed you, is treating a body in a manner that offends the sensibilities of an ordinary person. Wrapping a person in 3 garbage bags, putting them in a suitcase, driving them out into the wilderness to unceremoniously plop them on the side of the road on an embankment down by a river is offensive. Plain and simple. No reasonable person thinks that's acceptable. Especially once you know that the family's looking for her. Sure, he dumps the body on the 23rd, but when the family's looking for him, mum's the word. In fact, even after the family breaks into the apartment looking for her, nothing. First-degree murder. In order to convict the defendant in this case, you have to find several things. First, the venue that this crime happened in Hamilton County. You heard the testimony of multiple witnesses. Mr. Chen's apartment, 110 Tremont Street, specifically apartment 210, is located on the North Shore community of the city of Chattanooga. Chattanooga is in Hamilton County. We have proven venue. Next, we have to show that Jason Chen is the person who committed the crime of murder. Next, we have 3 elements. That Jason Chen unlawfully killed Jasmine Pace, that he did it intentionally, that he did it with premeditation. Again, going back over venue, you've seen it, you have a map of it. North Chattanooga. We've kind of gone over this a little bit, but I do think it's important to point out because it goes directly to the heart of identity. You can see it in Exhibit 129, 21, 129, and when you watch Exhibit 129, the Arctic video, you'll see it yet again, especially the black, dark V-neck right there. That's Mr. Chen pulling that suitcase. The suitcase that contained Jasmine Pace's body. So we can point out all the similarities. It's like a fingerprint. He's got his anything goes hat, his black shirt under his zip top with his black pants and his white man's shoes. Oh, which are in evidence as well. Exhibit 157. We know that this is Mr. Chen and not some other individual wearing a anything goes hat with a black shirt and a quarter zip, because when he enters the Walgreens and buys some Bounty paper towels, he uses a credit card. That credit card has numbers on it. Those numbers match the wallet collected from his Nolensville residence where he was staying with his parents. And you'll see that it's a match. Furthermore, the garbage bags that contained Jasmine Pace's body that were found inside this suitcase have not one, but 2 different fingerprints belonging to Mr. Chen. We also heard from Detective Crawford during his direct examination about slippage injuries to Mr. Chen's hands. All of that circumstantially shows that Mr. Chen is the same person that we see on the videos is the same person in possession of the physical evidence in this case. So let's talk about intentional. 60 stab wounds. 60. Not 1, not 2, not 4, not 20, not 30, not 45, 60 individual stab and incised wounds were on Jasmine Pace's body at the time she was examined by the medical examiner's office. That means stab, action 1. Removing, action 2. Each stab in and of itself consists of 2 distinct movements. The movement plunging the knife blade in and the movement removing the knife blade out. Back in, out, 120. 120 times. He had to move his body to be able to inflict the number of injuries that we see on Jasmine Pace's body. Dr. Cogswell, our medical examiner for Hamilton County, opined that the cause of death was multiple stab and incised wounds. So let's talk more specifically about the premeditation in this case. Using the understanding that we had earlier regarding the example with the traffic light, that it can be formed in an instant. There's evidence of preparation, the number of injuries inflicted upon Ms. Pace, as well as his conduct after the fact, all show that this was not some act of somebody who didn't know what they were doing, but somebody that had a plan, carried it out, and carried it out well. You've got to ask yourself, if Ms. Jasmine Pace is in the fetal position, if she wasn't moving, like the medical examiner told you, if the incised wounds are on her left arm, right shoulder, no significant injuries further down, head and neck, but only on the right side, the chin and the eye, what does that tell us? What about the lack of stab and incised wounds to the left side of the body? What about the lack of stab and incised wounds to the front of her body? What does that tell us? It tells us several things. Oh, excuse me.
I got on no source.
Beg your pardon, Your Honor?
I got on no source. Let me know when you're ready. I'll remind the media of the court's admonition not to broadcast graphic images.
Okay.
Ready?
Yes, sir.
Austin, you like that?
Yes, sir. I warned the audience, I warned the media. It's consistent with Jasmine Pace being found. She's being stabbed. If someone were stabbing a person 60 times, we would expect them to try to get away. But what if they can't? What if they can't because their right hand is chained to their right leg, their left leg chained to their right elbow? Makes it difficult to run. Makes it difficult to do anything. Dr. Cogswell told you that she was stabbed in the fetal position 60 times. We'd also expect that if she's being attacked on the right side of her body, that she might try to defend herself with both hands. There should be injuries on both hands. Instead, what we have are injuries to the left hand, no significant injuries to the right hand. That's consistent with her being in the fetal position with a hand unable to move on the ground. It's consistent with exactly what we see on the screen right there for being handcuffed. We also see additional injuries on Ms. Pace at the time of autopsy. We don't know what caused them. We can't tell you. But what they are consistent with, according to Dr. Coswell, is the application of pressure of some kind of throat, the application of a large amount of force to the rib cage, and some bruising to the nose right next to the right eye. And we also have bruising to her right arm. Let's talk about the restraints for a minute. The handcuffs and the shackles. Primary interest are these shackles. The defense insinuates that the shackles were not placed on Ms. Pace before the stabbing took place. Why? Because if you shackle somebody and then stab them, well, that's taking a step to accomplish what you do. You're confining somebody, you're making it easier to stab, but there's a problem with that. Dr. Cogswell told you that dead people don't move, right? Makes sense. Don't know that it would require a medical expert to say that, but it is a truth. These are the shackles. Ankle, arm, connected at the elbow. Why would Jason Chen take the time to apply a set of broken shackles to somebody? He wouldn't. But dead bodies don't move. You know what do move? Somebody that you're trying to stab 60 times. They don't move much if they're shackled. They don't move much if their right hand is handcuffed to the inside of their right ankle. But ask yourselves, why did the handcuffs not break? Well, you get a whole lot of momentum. Your leg and your hand are tied together. You can't really kick because you can only go as far with your leg as you can with your arm. But guess what you can do with these shackles? You've got more length to work with to build up momentum and snap the chain. Not enough for Miss Pace to get away. No. Not enough for her to get away. She had two sets of restraints keeping her right arm down there so she couldn't fight back with her right hand. Only with her left. You can see it right there. It's broken because Jasmine Pace fell back. It's broken that because when Jason Chen put those cuffs on her, she tried to get away, but was only to break free with one set. Couldn't break from the second. That's all it took. It's all it took to keep her in one place so that he could inflict a total of 60 stab and incised wounds on her little body. That's all it took. Having her in the fetal position with one arm chained to her right leg on the inside. And let's think about it. Why on the inside? Why not the outside? If it is, as the defense would have you believe, that Jasmine Pace was cuffed up while she was dead, right? Why on earth would they apply One shackled to the elbow and the other one to the left leg. She's not moving, she's not going anywhere. You'd make it so that it matches, right? You want her to be in as tight of a package as possible to fit into this teeny little suitcase that's not designed to hold a person. She's not moving. Cuff the hands together, shackle the two legs together, and pull them together. You wouldn't go haphazard, right hand to right leg, and then attach a cuff here and attach the shackle to the left leg. That's indicative of she doesn't want to be shackled. He's just slapping the shackles on whatever he can find, whatever he can get his hands on. It's been insinuated that this was a crime of passion. Chen blacked out, didn't know what he was doing. 60 stabs, wakes up, what have I done? I want you to remember something. Dr. Cogswell told you that the injuries inflicted on Miss Pace, Jasmine, were from two categories: antemortem, paramortem. He emphatically said, I found no evidence of postmortem injuries. Remember that testimony? You mean that a crazed individual who doesn't know what they're doing knows the precise moment to stop stabbing? Or would somebody who's acting under some kind of a passion that just keeps stabbing, they would keep going after they're dead? He used the precise amount of force necessary to accomplish his goal, and then he stopped. That's evidence of premeditation. It shows that he knows what he's doing. It shows that he's in control of his actions. And we can see it there in 204:11. That's a paramortem. I want you to think about it. If you're stabbing somebody and you've slit their throat, severed their jugular, the epiglottis, so that she's now inhaling and choking on her own blood, aspirating it into the lungs, creating that, I think it was leopard print pattern, cheetah print, I forget. But the pattern inside the lungs, that's not a quick death. It's not an instant kill. Remember the questions were asked of Dr. Cogswell? That would immediately incapacitate her, wouldn't it, doctor? Not necessarily. So then you move on to somewhere else, another vital organ. The lung. The head. But you want to know what happened with the lung? The knife blade broke off. It made his job much more difficult. We know that some of the wounds, like the through and through of her hand, the through and through of her neck, and the one that broke off in her back, all had to happen ante-mortem with the knife blade still intact. But what we do know is that not a single one came after she was dead. What are the odds? And during Dr. Cogswell's testimony, there was a question from the jury, and it was a good question, a very good question. How many of them, of the wounds that you saw, were downward? But remember, Dr. Cogswell always talks and describes in standard anatomical position. Up means towards the head. Down means towards the soles of the feet. Right means towards the victim's right hand, and left means towards the victim's left hand. Front, the front of her body. Back, the back of the body. But remember what Dr. Cogswell also said, that he believed that she was in the fetal position, which could be accomplished in only two ways. Standing on the flat of her feet like this, or on her side on the ground. And if we're talking about on her side on the ground, the standard anatomical positioning gets tricky. you'll have the autopsy report back there. And a question was asked, were any of them upward? Any of the wounds indicating upward? And that doesn't necessarily mean up towards the sky. It just means, for instance, in this case, an oblique stab wound on the right web of the neck penetrating upward through muscle only is generally in that direction. So as you read the autopsy report, remember, upward doesn't necessarily mean that she was standing. What it could indicate is that she's on the ground. It's just the knife's angled, traveling from one direction to the other. Now, we've already talked about this, but after he stabs Miss Jasmine Pace, after he disposes of her body, he's disguising his appearance. That's a higher level function of Mr. Chen's brain. He is thinking about, I don't want to get caught, so what can I do to avoid detection? He's got to clean his apartment, which he's already started doing, but how can I not be recognized when I'm going out disposing of various pieces of evidence? So he disguises himself. And just if there's any doubt, on the bed, this hoodie was collected. You can see it's stark white pull tabs. And this shirt. And when you watch the video frame by frame, you can see the pattern. And it's a match. And he left it in the crime scene. Another interesting thing that he does is he starts changing his habits. When you see him check out at Walgreens, when you see him check out at Walmart, when you see him running around, he's using his phone as his wallet. But, inexplicably, when he gets to Nolensville, his phone, which he uses as his wallet, is now inside a red jewelry box in a bedroom. And he's transitioned to an actual physical wallet that heretofore on the videos you've not seen. Why? Because he's concerned he's now being tracked. He can't take his phone with him, or it might give away where he is. And he stages the scene. We know he stages the scene based upon the physical evidence. The giant saturation stain on the left side of the bed, on the north wall of the bedroom, the oil stains along the east wall. But when law enforcement arrive, his bed has moved. It's now up against the north wall, covering up the stain. But don't forget, Exhibit 72, crime scene photograph, shows indentations in the carpet consistent with an item having been recently moved. What item? Well, there's a nightstand that's the same general shape in the corner next to the bed. Also, in Exhibit 117, you can see Mr. Chen with his bed very clearly centered on the east wall. Why would he move his bed? To cover up the large blood stain on the carpet, where Miss Jasmine Pace, to quote Dr. Cogswell, leaked. This is circumstantial evidence, personified. Do you see the black stain on the right side of the left shoe? It's right there. Go through the crime scene photos. He likes Vans. It's a pink pair, got another white pair, in boxes. Where's the rest of the knife? Never been found. We don't know where it is because Mr. Jason Chen after stabbing Jasmine Pace, disposed of that too. And obviously, we've already talked about this, the body. We've also talked about the manipulation of digital evidence. About that as well. Everything he does is calm, it's collected, and most importantly, it's rational. Everything he does is to a point, and that's to escape capture. Everything he does leading up to the attack by shackling and restraining Jasmine Pace is to make it easier to accomplish the act itself. That is premeditation. It doesn't matter that he didn't have it written down on some sheet of paper. Today will be the day that I kill Jasmine Pace. All that matters is he took steps to commit the murder. He committed the murder. And during the commission of the murder, you mean to tell me that during any one of those 60 stabs, he never once thought, I should stop? No. Like the car approaching the yellow light, it was hammer down. Keep going. Don't stop. The defense's theory is that this all happened in the bedroom. This was been insinuated. They're expert. Something big happened in the bedroom. The defense postulates that the blood in the bathroom is because Mr. Chen crawled on the floor and took his shirt off. That's how the blood got there. Remember that question being postulated to the defense expert? It's possible. Is it reasonable? We'll talk about it. Their own expert described the collection of evidence was he was testifying on direct examination yesterday. CPD, crime scene, did a good job collecting things with the knowledge that they had going on. Their own expert said that. I didn't ask that question. He just offered it to you. That was his opinion, unsolicited. He talks about crime scene contamination and how footprints through blood can move blood from one part of the apartment to the other. But he then, on cross-examination, admits that in order for there to be blood soaked through the grout, it has to be a large volume, sitting there for a while. Right? You mean to tell me that when the Pace family conducted their frantic searches of Mr. Chen's apartment, you mean to tell me that when the Chattanooga Police Patrol officers walked through, they trampled through enough blood to soak through grout and produce that pattern on the underside? That's unbelievable. It's incredible, and it's unreasonable. Now, he did tell you that what we have here in Exhibit 179-6 is an impact mark. Remember his testimony about that, that you can infer the direction based upon the angle of the tail of the blood drop, that as it impacts the surface, it creates kind of a teardrop shape with a little dot. See the little dot? And then from that, you can infer the direction from which the blood came. And in this case, he agreed, when shown this photograph, 179-1, that where the blood came from that's over 6 feet off the ground was, lo and behold, the red area outlined here in the bathroom, not the bedroom. He also is of the opinion that despite the blue star lighting up like this, that's just transfer. Even though that's in the same room where we see the impact mark with direction indicated. His opinion is that the attack happened in the bedroom and that this is the result of massive bleeding. He says that he could see in these photographs that there are scuffs on the wall, and that's indicative of something happening there. Remember that testimony? Scuffs on the wall. He tells you that he can't see drag marks, but he did recognize a blood trail going from the bathroom past number 6 under the bed to the large saturation stain that we saw in the preceding photograph. He also tells you that he could see in his photo what he believes to be 3 fingers. I don't know about your fingers, but when we put that picture up on the projector, I ask you to agree fingers aren't in a straight line. How perfectly straight were those lines of the fingers? I ask, isn't it possible that it was the folding of the sheet over on top of each other and a transfer in that manner, not a fingerprint? He couldn't say. In light of all of that, counsel asks, would that blood have been transferred by Jason? I don't see how it would have. Remember, he was asked about the attack and would that have created a large volume of blood, a large amount of blood? And he said, yes, it would have gotten everywhere. Jason's arms, his chest, his shirt, even the back of his head. Well, if that's the case, remember what Dr. Cogswell said when he was describing the position of Jasmine Pace's body on the large carpet. He said that her head, when we had it splayed out here on the floor, and remember the 2 straight corners, north wall, east wall, north wall, east wall, okay? Head was here, posterior, buttocks here, legs tucked up. Remember that explanation? If that's the case, well, that's not much room in which to stab someone 60 times, is it? It's also curious. How would you be positioned to be able to even inflict those wounds in that little area? It's not reasonable. The explanation makes absolutely no sense. I mean, don't forget, it's an attack that literally broke the knife blade off. A violent attack, creating blood that would have covered both the victim and Jason Chen. But ask yourselves, if that headboard was up against the wall, meaning this is the side of the bed exposed to that violent exchange, where's all the blood? All we have are these little red spots. A couple small little transfers. Where's the blood on the maroon sheet that was pulled all the way down? Ask yourselves, if the attack severed the ulnar artery on the hand that's free, you mean to tell me that Dr. Cogswell, who described arterial bleeds as spurting, that there's not blood everywhere, just in a little puddle? Where's the blood? On the floor, no doubt. We'll agree to that. Where's the impact stains? On the bed, the wall, door frame, the molding. Where's the blood? Dr. Cogswell told you in his testimony, follow the blood. And it just doesn't follow. Here's the sheet. If Mr. Jasmine Pace was stabbed 60 times within a foot or so of this bed and that sheet, in the manner described by Dr. Cogswell and their own crime scene expert, it would be soaked. But it's not. All we can see are some red stains in the carpet. Rather, ladies and gentlemen, the proof in this case, the scientific proof, even the testimony of the defense's own witness, Mr. Lawrence, establishes that the more violent, aggressive, physically impressive acts occurred in this room, the bathroom, in that area right there. I want you to think about this. In order to soak through the grout that we see in the preceding photographs, that would have required a large puddle for an extended period of time. The blood stain at Exhibit 6 is consistent with blood running off the end of the tile and beginning to soak into the carpet. No doubt the defense expert is correct. Carpet is absorbent. And it started wicking the blood off of the tile floor before Mr. Chen had an opportunity to soak it up. Whose blood? TBI tested it. It's Jasmine Pace's blood. Jasmine Pace's blood found on the threshold in the transition from the bedroom to the bathroom. The impact marks lead back to the large puddle of blood, to the large puddle of Jasmine Pace's blood. And oh, by the way, 159.12 and 159.13, remember he said there's an impact mark on the threshold of the door in the bedroom, and it ran down and then puddled a little bit? That blood will do that. It'll impact, it'll drip, and then it will stop. And we got that on the bathroom. But hey, it didn't happen there. It's what their expert thinks. Despite the fact that the bathroom lights up like this, he says it's all contamination. That's his opinion. All of this is contamination. He said it over and over and over and over again. Contamination, contamination, contamination. Everybody's contaminated. I'm contaminated. Everyone's contaminated. You want to know where the Paces, the police, the crime scene units aren't walking with their feet? How about the doors? It's not contamination. That's Jasmine Pace's blood, because that's where Jasmine Pace was murdered. Further proof of a cleanup as if you need it. He's buying paper towels. He's buying cleaning supplies. And yet the only thing that we can find, despite Mr. Lawrence, a nice gentleman, okay, saying that Mr. Chen didn't do a thorough cleanup job, yes, he did. All we have is blood and grout and a discoloration stain from where she was brutally murdered by Mr. Jason Chen. Further proof of it. Further stains in the grout. Let's talk about voluntary manslaughter. Defense has said provocation. Provocation, provocation, provocation. Based on what evidence? Courtney Paglino Bruin said she heard him argue. You've seen an awful lot of arguing in this courtroom over the course of this trial. An argument is not an excuse to murder somebody. Just because you have a disagreement with somebody and they're yelling, that's not adequate provocation to lead an otherwise reasonable person to act in an irrational manner. Mr. Chen is always a rational person in everything he does, whether it's posing as the victim online, whether it's sending the family messages, whether it's turning her phone on and off, whether it's using her phone to try to hide his activities, everything's with a purpose, including chaining her up. There's been absolutely no evidence other than there's a disagreement. She sounded sad. The female voice sounded sad but assertive. And she screamed. It's not provocation. It's a nothing. She's not there. What would cause a reasonable person to act unreasonable? It was posited earlier that it was a wine glass. Where? Ms. Brewer didn't hear crashing. She didn't hear breaking. All she heard was running away from the back of the apartment towards the front. Is that consistent with the story that we were told earlier? No, it's not. It's consistent with Ms. Jasmine Pace trying to get away, being stopped, being restrained, and then being murdered in the room that, guess what, is in between the bedroom and the front door. Mr. Chen was able to stop her before she got out, and that's where he handcuffed her, and that's where he started stabbing her. Did she bleed a lot in the bedroom? Absolutely. Absolutely. But even when you were shown the carpet with the giant saturation stain, you can't say that's Jasmine Pace. You remember that question being asked over and over? Then whose is it? Every explanation that has been given for Mr. Chen's conduct up until this point has been disproven. Remember, don't forget, ding ding. Ding ding. Ding ding. That's what set Jasmine off. But you've seen the Tinder records. And it's not there. What this shows is a person who may have had an aggressive emotion during the attack, no doubt. Every murder is aggressive. Every murder is emotional. That doesn't mean that it was provoked. Ladies and gentlemen, Mr. Chen unlawfully killed Ms. Pace. He acted intentionally. The number of wounds, his restraining the victim before the attack, his conduct after all shows calm reflection on the task at hand. And that's why he's guilty of first-degree murder. Go find him guilty for snuffing out Ms. Jasmine Pace's life on the 23rd of November, 2022, at 2 o'clock in the morning. Thank you.
Ladies and gentlemen of the jury, on behalf of Jason Chen and his defense team, we appreciate your attentiveness during the course of this trial. This has been a difficult trial. Jasmine Pace's life was taken on November 23rd, 2022. Jason Chen did that. Jason Chen and Jasmine Pace have been in a relationship on and off, as you heard testimony, for about a year. On November 22nd, just before midnight, Jasmine Pace came to Jason Chen's home at 110 Tremont Street, apartment 210. It's undisputed. What happens between 12 o'clock and 2 o'clock? There's no proof of it. But we do know just after 2 o'clock in the morning, Courtney Brewer was awakened. She was awakened by what she described as a female scream. What we know is that Courtney couldn't describe what was being said. She couldn't say to you, she couldn't answer any questions about what the argument was over. She described it as something that you couldn't decipher. Emotions are up, pulses are up, everyone's aggravated. Jason Chen's scared. Jasmine's upset. Jason's upset. And Jason killed Jasmine. He got a knife, and 60 times Jasmine was stabbed. That hasn't been disputed by the defense since the first day of this trial. What's been disputed is the state's allegation that this is premeditated. You as a jury have the most important job. You're going to retire to a jury room, and you're going to be looking at all of this evidence. You're going to be looking at all of the testimony, recalling the testimony that you've heard from all of the witnesses. Investigator Crawford, Dr. Cogswell, Courtney Brewer, CSU investigators. You're going to be going through mounds of evidence, days of testimony. And like the general asked you during jury selection, you get to use your common sense. You get to apply what you know to the facts and the evidence that's been given to you. What we know is that from just after 2 o'clock in the morning, everything that Jason did showed that there was no plan. It showed that he wasn't acting rational. Rational people don't shackle individuals and put them in garbage bags. They don't shackle the individual, put them in the garbage bag, and put them in a suitcase. They don't go the next day to Walgreens and Walmart to get cleaning supplies. They call the police. Everything that Jason Chen did was disgusting. It's unacceptable. That's not refuted by the defense. The state would like for you to believe that everything that Jason did from just after 2:18 in the morning until he was in Nolensville was part of the plan. He left breadcrumbs everywhere he went. He got Jasmine's phone. He used her phone. The state has asked you to believe that Jason had full control of her phone from 2 o'clock on, but they don't want you to think for a moment that he yet again made a mistake. He tries to not share a location, stop sharing a location, and drops a pin. They want you to believe that Jasmine was shackled when she was being stabbed. Dr. Cogswell was asked very specific questions, questions that you can remember. You can look back through your notes. You can recall his testimony and discuss this among yourselves. There were no ligature marks on Jasmine's wrist. There were no ligature marks on Jasmine's ankles. There were no cuts. There were no bruising. The state would like for you to believe that's because she couldn't move. She couldn't break the shackles. She couldn't break the handcuffs. The reason they aren't there is because they were not applied so that Jason could stab her. They were applied so that he could fit her into garbage bags before putting her into a suitcase. if the state was able to establish that she was cuffed and shackled, there's your premeditation. They don't have that. You don't have that for the proof either. What you have is the state's argument to you today. That's the theory you should believe. And their own expert refutes that. No defensive wounds, no ligature marks, no bruising, no cuts. An individual that's fighting and tied would surely have that. Jason is charged with 2 counts. Abuse of a corpse, first-degree murder. When you're in this jury room, you're going to be tasked with finding him guilty of an offense beyond a reasonable doubt. What is that? Reasonable doubt, beyond a reasonable doubt, is going to be the elimination of any doubt that Jason Chen committed these offenses. Let's put them side by side. The abuse of the corpse charge. A reasonable person would not believe that it's acceptable for Jason to put Jasmine into trash bags after she's been shackled, put her into the suitcase, drive her to Suck Creek, and discard her. No reasonable doubt would a reasonable person have. That's not acceptable. That's unlawful, and that he's committed that offense. When you're in the jury room, though, do you have that same confidence related to premeditation? Do you have the same conviction that Jason knew what he was doing, that he intended to do this, and that he had the plan to do it? The law is clear. We're not asking you to believe that Jason had hours, days, months that he's planned this out. But you have to know with moral certainty that he had a moment to reflect and that he didn't. It's the state's burden to show you that he had that moment of reflection and that he chose to disregard it and to continue to engage in acts that killed Jasmine Pace. Ladies and gentlemen, that's not here. You've heard from Courtney Brewer about the yelling, something that she can't even describe to you what was being said. Movement throughout the apartment. Jason's actions from that point forward, while are not acceptable or adequate. If you believe that Jason was provoked to a point of being in fear or terror, then you're going to be looking at the jury instructions specific to voluntary manslaughter. I'm going to pull up on the screen here what specifically you need to look at in the jury instructions regarding premeditation. When you're dealing with premeditation, and I'm going to read this to you, but you have the ability to read it yourself. It's a premeditated act that is done after the exercise of reflection and judgment. Not one, but both. An exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act. What we've heard for days is everything Jason has done after. This is not you going to the jury room and determining that there's post-meditation. It's premeditation. Everything that Jason did before Jasmine's death. It's not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The state says each of those actions, 120 movements, that Jason should have had the ability to reflect. They haven't shown that he did. What you need to look at also is in Dr. Cogswell's testimony. He talked about the injuries that Jasmine sustained. He talked about how they were centralized, how there wasn't a pattern, that it seemed erratic. It seemed as if someone was in a state of excitement, a state of passion. When you're looking at the lessons that the judges already instructed you about, when you go into second degree or voluntary manslaughter, when you find that the state has not met their burden to prove premeditation, you're going to be looking specifically at the distinction between what is second degree murder and what is voluntary manslaughter. Specifically, voluntary manslaughter requires that the killing result from a state of passion. The state's witness talked about this. They talked about the individual that inflicted these wounds being in a state of excitement or a state of passion. Right here, in your jury instruction. That is something for you to consider. It does require that there has to be a state of passion that's produced by adequate provocation. You heard yelling from the floor below. That was enough to wake an individual up at 2 o'clock in the morning. So loud that she couldn't even make out what was being said. There's an argument. Provocation. When you're looking at the next step, it would lead a reasonable person to act in an irrational manner. The state would like for you to believe that he was cool, calm, and rational. Irrational people do the things that Mr. Chen did. On the next slide, when you're trying to determine what the state of passion is, passion means human emotions such as anger, rage, resentment, terror, similar emotions which render a mind incapable of cool reflection. If you find that there was provocation, that you believe Ms. Gruber, that she heard a female screaming, so loudly yelling that nothing could be made out of what she's saying. Anger. Jasmine is angry. Jason. We don't hear that Jason's yelling back or that Jason's screaming at her. We hear that a female is yelling. If you find that there was a specific issue of whether or not Jason could have been in a state of passion, you can't form premeditation because he can't reflect. There's no moment that he could have for full reflection. During the course of this trial, there were a lot of questions that were raised about the investigation of the Chattanooga Police Department, about the collection of evidence, about the time that it took for law enforcement to get involved. This wasn't to distract you or to try to make it look like Jason didn't commit any offense. It was to make you aware that the state's going to ask you to rely on this evidence of this scene. That one, Jason contaminated, but so did every other individual that went in afterwards. They want you to believe that this scene is pristine enough that it sets a story up that Jason acted with premeditation. Cleaning a scene after the fact does not give you premeditation. Removing Jasmine's body, shackling her, putting her in garbage bags, and putting her in the suitcase and discarding her on the riverbanks doesn't give you premeditation. It gives you the use of force. How Jasmine was discarded is not acceptable. Jason should be held accountable for that. Jasmine's death is not acceptable. Jason should be held responsible for that. When you're in the jury room, and you are looking through these instructions, it will be important for you to remember it is the state's burden to prove each of those elements beyond a reasonable doubt. First-degree murder requires premeditation, as you saw on that first slide. The state has to prove that beyond a reasonable doubt, and it has not been proven. You will not find first-degree murder. But when you're evaluating the jury instructions and the other charges available, ladies and gentlemen of the jury, you will find that Jason Chen did unlawfully kill Jasmine, that he acted in a state of passion, and that he committed the offense of voluntary manslaughter. One of the things that the state did talk about, and I'm going to touch briefly on that, is what's been shown as 226. You guys can recall this red sheet. The state would like to talk about traces in the sheet, possibly not being blood. You have the ability to look at this. We don't know what this is. You won't be able to see anything but this picture in the back, because the state doesn't do anything with the sheet other than collect it. It's not tested. It's not brought here for the trial. So you have a picture. Why we don't have it here, I'm not sure. But it does raise questions as to what this could be. Why is it not preserved? Why is it not entered here? Why is it not tested? This is among many things we don't have answers to. The state also mentioned a few months ago antemortem, perimortem, and postmortem that showed none detected for postmortem. Dr. Cogswell, in his testimony, said that the time that it takes to inflict those injuries, the 67 wounds to Jasmine, is not the same amount of time it would take for her to die. You can remember that. He said that more than once. The fact that an individual is stabbed 60 times does not mean that she died instantly. You heard about her continuing possibly to bleed out. Jason Chen did not stop stabbing because he thought she was dead and that was good enough. There's no evidence that supports what the state has just said to you. Dr. Cogswell's own testimony refutes what the state just stood here and told you. Dr. Cogswell said that the amount of injuries that were placed on Jasmine, she would have died after the infliction stopped because of the amount of bleeding that she was doing. I know that I've just said this to you, but I'm going to say it once again. This has been a hard case. Jasmine deserves justice. You have given Mr. Chen the benefit of a fair trial. Your attentiveness has been very clear throughout this, and it's much appreciated. In reviewing this evidence, we ask you to return a verdict of voluntary manslaughter. Massachusetts Chen. Thank you.
Let's stay.
Wow. In opening statement, I told you that we would give you the dots and we would help you connect them. Every single fact we mentioned in opening statement, we proved beyond a reasonable doubt. Every single fact we committed to, we proved to you beyond a reasonable doubt, because that's what opening statements are for. To give you the evidence you're about to see. And then you heard from Mr. Chen's attorney, who committed to a very specific story. Remember, we didn't just talk about that story, right? We've backed off that story because, that story doesn't work anymore. And we're going to talk about that story. This entire trial has been muddy the waters. It has been muddy the waters to confuse the jury. The opening statement from the defense was meant to confuse you. It was meant to have you thinking about other things, possible defenses, that the state disproved. Not only did you not hear evidence of what they said in their opening statement, the state outright disproved it. That's why you don't hear it today. That's why we're not going to go back over the defendant's story. And you had asked about transcripts of opening statements. Let's talk about what we committed to in opening statement as Jason Chen's attorneys. They met on Tinder, wrong? You have text messages. They met on Bumble. Simple thing, but we're just starting with the untruths that the state disproved. They traveled to Chicago together that summer, wrong? End of October. You have text messages that show that he asked her to go to Chicago. You heard that you will see messages where you will see that one of them likes one of them more than the other. Oh, that Jasmine liked him more than he liked her. Wrong. You never saw proof of it. In fact, you have all the messages that they didn't want to show you. They wanted to put them in evidence and then just hope that maybe you'll waste your time reading them. So what did I do? I put them on the screen for you. That weekend before he killed her, he asked her to come over. Oh, she likes him more? No. If you want to waste your time reading the messages, read them. You'll find out that that was not true. What they committed to an opening statement was not true. They drank wine, smoked pot, smoked wax. We didn't hear that just now, did we? Why? Because it's not true. They committed to a story to throw mud at the wall, and it was never true. It was meant to confuse you. And then also, how offensive. The victim drank wine, so he murdered her. The defendant was smoking wax. No proof of it. Zero proof of it. Didn't happen. But let's say that it did. The defendant smoked wax, marijuana, so he murdered her. That is no defense. But it's certainly not a defense when you say it and you never prove it. You committed to this in your opening statement. And by the end of trial, when the jury's no longer confused, you don't want to talk about it anymore. In order to open one of the bottles of wine in the bedroom, Jason had to go to the kitchen and get a kitchen knife to take off that plastic wrapper that goes around the top of the wine bottles. We've seen that knife. Well, we've seen part of it. We'll never know where the other part of it is. We've seen part of it, right? So he was able to get it off the top of the wine bottle. They finish off the bottle. She goes into the kitchen to get another one, and she sees those Tinder messages. The Tinder messages are significant, mostly because that was their adequate provocation. The only adequate provocation you ever heard in this trial was an opening statement, which is not evidence. And then what was the state able to do? Through an expert, who nobody can deny that Mark Hamilton is an expert. He put those Tinder records on the screen and he explained them to you. They are records that cannot be toyed with. They are records that T-Mobile holds regardless of whether you delete things. Those are his Tinder records. And not only did he not have Tinder notifications from that morning, he didn't even have Tinder notifications from November 22nd. That was their adequate provocation. It didn't happen. We know for a fact it didn't happen. So now they stand up here and they say, adequate provocation. He was provoked with zero evidence. What the evidence was is that he chased her to the door of that apartment. Miss Paglino Brewer was the state's best witness, and I didn't even call her. I wish I would have. She nailed down our timeline. If you didn't already believe the timeline because she sent her mother her location at 2:18, Courtney knows it. Courtney looked at her phone at 2:11 in the morning after she heard a scream of a woman in, quote, distress. And here's the kicker. They want you to believe this fabricated story that there's no proof of. But how does Courtney help us? Because she attacked Jason. Again, we're uncommitted to this story now, but let's just go back to their opening statement. She attacked him with a wine bottle, and then subsequently, after he kicked her 98-pound body, according to opening statement, he kicked her 98-pound body to the floor where she fell on wine glasses. She then subsequently came at him with a wine glass and he stabbed her irrationally and very fast 60 times. Not true. Why? Because of Courtney and because of that phone location. Courtney was 2:11 a.m. The phone location to her mom was 2:18. 7 minutes. She screamed. Things happened. She was able to know she was in enough danger that she needed to send her mother her location. It wasn't fast. It wasn't fast at all, and we know that. 2:11 is 7 minutes from 2:18. It wasn't fast. She knew she was in danger. She tried to get out of the door, and Courtney told you that she heard a door slam. Jasmine knew she was in trouble. She had time to use her phone before he started killing her. Made up story. He kicked her. He kicked 98-pound Jasmine Pace, and then he ran away. But he couldn't get the bathroom door closed because of a bath mat. Couldn't close the door on 98-pound Jasmine Pace. So he had to run in his bathroom. He had to run to his bedroom. Jasmine's right there coming at him with this broken glass. In closing, they don't want to talk about the story that they committed to, because the story they committed to was that he killed her in the bedroom. And he gets, quote, and he gets back into his bedroom, and Jasmine's right there, coming at him with this broken glass. Jason sees the knife, and he reacts, and he stabs. Okay, we got two problems there. First of all, his own expert, who I wish I would have called, good expert, says that there's something that happened in the bathroom. There is blood spatter on the wall in the bathroom. Like General Moyle showed you, there is blood in the grout in the bathroom. We know she was moved. Why do we know she was moved? Because Dr. Cogswell testified that on the ground in the bedroom where you see all of the blood, which was almost all of the blood that was in her body, because he was only able to get a small vial of blood, because it had all leaked out on the carpet, that for that blood to be on the carpet, she had to be laying on her wound side. That's what he said. Because if she was not on her wound side, the blood would have soaked down to the other side of her body, and the medical examiner would have been able to see that. He said she was wound side down. We know she was moved. We know she was moved, and we know there wasn't enough room right there to just simply flip her over. She was killed. The stabbing began in the bathroom, and then he drug her into the bedroom where he put her on her side with the wound so she could bleed out. We know that. What else is the problem with this? Jason sees the knife and he reacts and he stabs. She's coming after him. He sees the knife and he stabs. The problem is, without question, over and over again, including in writing, our medical examiner says her wounds match her fetal position. It is not true. Trying to confuse you. Trying to throw everything at the wall and hope that it sticks. Really, the worst part of the opening statement is he's scared for what his future entails. But more importantly, the shame that he's going to bring on his family, the shame that comes with everything that he's being accused of today. Manipulative, selfish, he's scared for what his future entails? He's so scared that he texts on Tinder Victoria at 9:52 with some corny pickup line. He's so scared for his future that he's playing video games with his friends later that day. Don't worry about Jasmine Pace, who's dead in your apartment the entire day until 6 p.m. when you take her to Suck Creek Road. Keep in mind, when he Tinder messages Victoria, Jasmine is dead in his apartment. Uncontested facts. Is this the mindset of someone that just irrationally stabbed a girl 60 times? No. And then he lies over and over and over again. And this is something that General Moyle didn't mention. He lies to Katrina Pace on the phone. He says he hadn't seen her since Saturday. A lie. Then he gets to his parents' house in Nolensville, and he's trying to come up with a story. Not the story you heard Monday, but he's trying to come up with a story. It says, the last time I saw her was the 18th of November. The other note, the other sticky note on the desk, says the last time I saw her was the 19th. Trying to get his facts right. He knows he's being looked for. He knows law enforcement's trying to contact him. Why? Because he's got Zach Crawford's number written on a Post-it note. Does he ever say, hey, I killed her because she came at me with a wine bottle? No. He's got Zach Crawford's number written on the Post-it note. He's scared for what his future entails. I'm going to ask y'all to do something for me. It's been a long week. I'm only going to have a couple more requests. When you think about this trial in 10 or 15 years, you tell somebody about the jury that you had to serve on in Hamilton County, you tell them about the case. I don't want you to remember this case as the case of State of Tennessee versus Jason Chen. The trial of Jason Chen. I don't want you to remember it with the suitcase and the girl left on the side of the road. I want you to remember this trial as the trial for Jasmine Pace. Because we talk a whole lot about criminal defendants. You've heard the name Jason Chen a whole lot since we started jury selection last week. Victims matter. Jasmine Pace is not just some girl listed in an autopsy report. She is not the photos that you have seen. Don't minimize her to a name on an indictment. She is a person. She had family that loved her, that you've heard from this week. She was a friend. She was a granddaughter. Please don't minimize this trial to the trial for him. I'm going to ask that you take all this information, all the notes you've made this week, all of the closing argument information. You're instructed to go back there and begin with first-degree premeditated murder. Go back there together and find him guilty. Please. Thank you, Judge.
Ladies and gentlemen, come to the part of the trial where we'll select our 4 alternates at this point. You may be disappointed, you may be relieved, but if you are an alternate, you're not off the hook yet. You'll be kept separate from the other jurors in case something happens to the 12 that go back. We're not sure how long deliberations will take, but you will still remain part of an essential part of making sure that this trial continues until the final verdicts are in. first alternate will be Otis Anderson, juror number 2. You can't talk about the case among yourselves. You'll be kept in a separate room for now. And we'll let you know if you're needed. At this point, you need to go to excuse you, get your belongings from the jury room. The deputies will take you to another room where you can. Yep, whenever they're out of jury, just let me know.
I gotta go run back in here. No, man.
Let me know when they're out. While we're waiting, jurors, you are the final 12 that will be deciding this case at this point. 4 things I'll tell you. If you have any questions when you get back there about the facts, you are the judges of the facts. If you have any questions about the law, they're probably in these jury instructions. So reread the jury instructions if you can find an answer. If you still have a question, just write it down, knock on the door, and get it and talk about it and try to see if we can get an answer for you. And the final thing is that the deputies will show you where the light switch is, turn the light on if and when you reach a verdict. Members of the jury, you should enter upon the consideration of this case with due regard to the seriousness of the questions submitted to you for your determination, and you should strive to free your mind of all bias one way or the other. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality. Look to all the facts and circumstances and the proof before you. Make and report to the court such verdict as you think truth and justice require. You may now retire to the jury room for your deliberations. stand in recess till the jury has a question or verdict. instructions for the sentencing phase?
Yes, Your Honor. Of course, we were also going to spend some time on that in the next little bit.
Okay.
So we can look at it, but I looked at it last night. Pull it up right now.
I'll wait till Mr. Weiss gets here, but I think his parents may testify. If there is a sentencing hearing, if that's the case, I'd need to get into it for them, so I'd like to do. We may be coming back tomorrow.
Your Honor, would you like for me to move the exhibit so that there's not a pile in front of the box?
Sure. the jury has a verdict, state prepared to receive the verdict.
Yes, Your Honor.
Defense ready to receive the verdict.
Yes, sir.
Bringing the jury whenever they're ready.
Yes, sir.
All right, please be seated. Let's see, your name is Juror 15, is that correct?
Yes, sir.
All right, are you the foreperson of this jury?
Yes, sir.
And you arrived at a verdict?
Yes, we have.
Hand it to Reserve. Juror 15, if you could stand and read the verdict. Chen, stand with your turn. Start with respect to.
With respect to count 1 of presentment 315-228, we, the jury, find the defendant, Jason Chen, guilty of first-degree premeditated murder.
This is an emotional verdict. Everyone needs to maintain decorum, please. All right, rest of the jurors, if this is your individual verdict, please so indicate by raising your right hand. Record should reflect that everyone's right hands are raised. All right, sir, read count 2.
With respect to count 2 of presentment 315-228, we, the jury, find the defendant, Jason Chen, guilty of abuse of the corpse.
All right, rest of the jurors, if this is your individual verdict, please so indicate by raising your right hand. Record should reflect all right hands are raised. All right, maybe seated, sir. Maybe seated, Mr. Chen. We decide according for the polling of the jurors.
Oh, Your Honor.
All right, Mr. Chen, as 13th juror sitting in this case, I do agree with the jury's verdict of guilty and hereby pronounce you guilty of the first-degree murder of Jasmine Pace. This brings us to the sentencing phase of this particular matter. The jury will be asked to determine whether or not there's the presence of an aggravating factor. This will require proof. We're going to do that tomorrow. So at this point, to let the defense and the state put together any proof, if they want to put some on, then that'll be happening tomorrow morning. Again, you can't talk about your verdict with anyone. You're still part of this case, so you must refrain from being exposed to any media, and also must not talk about any sentencing matters or anything about this case with each other until you're back in the jury room. Okay? So that will release you, and I'll again remind you the court's admonition to not discuss anything about this case among yourselves until tomorrow. All right, that may be Please be seated. The last day will resume tomorrow at 9 a.m. There's a regular docket. It might be better for parties to be ready to proceed at 9, but how big's the docket tomorrow? That's it? All right, let's try it for 9:30. Unless you need more time tomorrow morning, we can start later in the morning if you wish. Mr. Weiss, if you need any witnesses, you need to get together. Same with the state. Do you prefer 9:30 or 10? Yes, sir, 10 o'clock. Okay. Court will be in recess till 9 tomorrow. This court will be in recess till 10 a.m.
Thank you.
Chen, make the point.
You don't have to talk to anybody about your experience if you don't want to. The lawyers understand that. They'll respect that. Just rather not talk to anyone. You don't have to. The lawyers do appreciate, and I certainly did when I was down there, getting feedback about what they did right, what they could do better. So if you are okay with it, they may ask you some questions about what is important to you in the case. Okay? we'll try to get you back to Nashville tonight. We'll work on that, okay? Thank you.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm, new paradigm. United and free. United and free. United and free.